The second sentence is that it would be reasonable for you to think, based on the evidence, that he now feels disrespected because Odin Lloyd should have be grateful he's allowed to spend time with the defendant. That's what he says that night.
That's right, but the context was, that's evidence, what Casey Arm had said. He said to her, you should be grateful.
Right, but I think a fair reading of that, or listening to that, is that that's what he said that night. So I can just clarify. You had earlier discussed what was said in the car with the women, and then you switched to the club.
Right, but that's an accurate statement of what he said that night.
It's not it's an accurate statement of what he said that night with respect to Odin Lloyd, about Odin Lloyd.
No, but I didn't suggest.
I think that's the way. I think that's a fair reading or listening of that.
That's how I heard it.
Well, again, I'm saying the statement itself was stated in suitcase when I made that perfectly clear, and so I don't think they could have misunderstood that in the context, because I just said that to them. I said, this is what he said to her, and then I said,
but the he goes, it would be reasonable to think he feels this, that's what he says that night.
That's he being the defendant.
Right. But he didn't say it that night. He didn't say it the night he was with Odin Lloyd.
Yes, he did.
The night he was with Odin Lloyd, he didn't say that he was being disrespected because Odin Lloyd should have thought he was
No, I was describing the incident room, why he was upset, or why they could find he was upset. He did say it that night. He said that probably 10 or 15 minutes before they walked out of the club to Casey Arm. So that's not a it's not a misstatement, and it's not mischaracterizing the evidence or even misleading the evidence. They clearly would understand that he did say that. I just said that to them.
If you could just maybe, do you have that up on the screen? If you could just read the previous.
I do think in context it sounds like what he was supposed to do.
Right.
That the intention was to have the jury think he said that about.
Well, it might not have been the intention, but.
Number two, Your Honor, I may be wrong, but I don't recall that Casey Arma so testified.
She did.
And again, I may be wrong, but I don't recall that testimony.
Well, I would respectfully suggest he is wrong, because I specifically had somebody pull that up to make sure that I wasn't misquoting what she said.
If you could just read the sentence 2 before, it would be reasonable for you to think.
It's a little ways before that, but it says, do you remember the point when she said, at some point you said to her, you should be grateful, I'm showing you attention.
Right. And then how many, and then this.
And I want you to consider that, because part of the evidence, not to show the defendant's bad character, Mr. Sultan suggested, consider his attitude, how he was behaving, what he was saying, how he was acting. That's important to understand what might seem insignificant to somebody else, disrespect, to be upset about something that maybe wouldn't matter. This defendant, Aaron Hernandez, remember from Mr. Bradley, took him a long time to trust people. He didn't want his business known. Well, you've heard he's brought Odin in some respects, and we'll go through the nature of their relationship.
Okay, so there's an awful lot that goes on prior to, it would be reasonable to think he feels disrespected because Odin Lloyd should have felt grateful. That's what he says that night. I think there's an awful, but I can, I don't believe that there was any intent to mislead. I think it can be easily corrected in referring to a statement made by the defendant at a club. There was no intent to suggest that the defendant made the statement in reference to feeling disrespected by Mr. Lloyd, because he didn't make that statement about...
But I never said that.
Well, I think that what you said can reasonably be so construed. I don't think you intended to say it, but I think it can reasonably be construed, since what you said is followed by, that's what he says that night. I think a reasonable juror could read that what he says that night is your previous sentence, and it's not what you believe you said, and it's not what you intended to say, and it's easy enough to correct that.
I object to the jury understood.
I think it's...
The context of what I said was factually based. They heard the evidence. You already told them if things that are said don't comport with the evidence, it's their memory. I said it, and to me, that's very clear. It was a statement made by her. I never said he said that to Odin Lloyd. I think that's reading too much into it.
It says, I don't think it's reading too much into it when it says that's what he says that night, and there's no evidence he said that.
That's what he did say that night. That's a true statement.
Not with respect to feeling disrespected by Odin Lloyd, because Odin Lloyd wasn't spending time with him.
No, but again, it was the whole context of
I understand.
his attitude, his behavior, all those things about how he was feeling, and that he did say that night to her, and that obviously that was relevant. That was the full context of what I was saying. It's relevant for them to determine his attitude and behavior that night.
Thank you. And with respect to the conversation with the babysitter, I will give a instruction about not speculating as to what words may have been used in the car. With respect to the...
And Judge, that, I reviewed that, and there was nothing inappropriate about it. There was no imaginary conversation.
But you're okay, you're okay.
That was what he said to her. She testified to that.
Right, but you say, I don't think that was the issue. The issue was, doesn't that sound remarkably similar to the early morning hours of the 17th and the long drive that brings him to Collis Landing? You're okay, you're okay. There was not, that is total speculation as to what words were used in the car on the way to Collis Landing.
Just with regard to a ride that he didn't want to take.
But there is
evidence of that. I suggest
that he said, you're okay to Mr. Lloyd? There's no evidence of that.
No, that Mr. Lloyd was taking a ride he didn't want to take as evidence.
Right, but this is what he said. This is
I don't believe I said this.
It says, doesn't it sound remarkably similar? These are words. Words would have to be, only words can sound in some fashion. And I will...
Circumstances can sound very similar.
The jury cannot make up or speculate as to what words, if any, were actually used in that ride.
I don't think it's calling for them to speculate. I think it's the circumstances. Doesn't this sound very similar? That's exactly.
But it can't sound similar to something when there's no evidence of what the words were.
No,
so in
circumstances, not words. You keep saying words.
Well, because only words can sound similar. You're okay. It's words that sound. I'm going to give a short, on the GSR, I think that the evidence would support an inference that the sweatshirt had something on it. I don't think that it was in the context of a reason to get rid of the sweatshirt. I don't think there's any way that the statement could be reasonably read in context of the evidence in this case that the Commonwealth is saying it was tested. We can bring the jurors back in. Before we do that, I did have two things. One, yes?
Can I just deal with this one thing, because this is something that was said that I'd ask you then to instruct the jury. They said the drive wasn't hash. Mr. Sultan did.
The second one, there was testimony of that the first clone was hashed, and then Mr. Reset testified that was overridden, and a second one was then produced, and that second one was never hashed. That's what he testified to.
Right, but the drive being hashed was by Conrad. That was a different...
First one was hashed, then a second one was, a second cloned copy was produced, and he did not know one way or the other. He didn't say it wasn't hashed, he said he did not know one way or the other, so there was no evidence in this case that the second cloned copy was hashed. He said he didn't know. He was told that he understood the first one was hashed. He explained how hash meant that it's a way to verify it's identical. He then testified that it was overridden, so a second one needed to be done. A second one was done, and he was asked, was the second one hashed, and he said he did not know, so there's no evidence in the
The
case.
statement was the drive wasn't hashed. That's not correct. Trooper John Conran testified that the original drive was hashed.
Right, but it's not, it's the cloned, second cloned copy. The one that he testified was
He
hashed.
testified to both, Your Honor. Okay, so if we're
Two
gonna-
clones.
Correct, that each one was then hashed. So him suggesting that somehow there's a unhashed one, that's not accurate. And so, again, the same request, that if that's the case, then the jury be instructed that,
I don't know what the officer originally testified to. I'll make some reference to them. We had not talked about the credible evidence the defendant was affected by consumption of alcohol or drugs in the context of the firearms charges. The second one is on June 22, and there's no evidence of that. And are you seeking it with respect to the first one in terms of knowledge that what he had was a firearm or intent to control?
On the firearms charges?
Yes.
I'm not requesting that.
It is the court's practice to give the jury a written copy of the charge. I don't tell them that till afterwards. We can bring the jury in. Before I begin the charge, just a few things with respect to the closings. In referring to a statement made by, evidence of a statement made by the defendant at a club, there was no intent by the prosecutor to suggest that there is any evidence that the defendant made that statement in reference to the defendant having feelings about being disrespected at the club by Odin Lloyd. In referring to the pickup of Odin Lloyd, there was no intent by the prosecutor to suggest that there's any evidence of an actual conversation that may have occurred in the vehicle as the vehicle was driving to Collis Landing. And you, of course, cannot speculate or make up in your own minds an imaginary conversation or speculate as to what was said, if anything, in that vehicle. With respect to a reference in the defense closing, that the second cloned copy of the hard drive cloned after the first was overridden. I would just ask you to, as with respect to all statements or summaries of the evidence in both of the closings, to rely on your own recollection as to whether or not there was testimony that in this case, whether or not there's evidence in this case that a second cloned copy was hashed. We are now at that stage of the trial of this case where it is my responsibility to give you instructions concerning the law. It was obvious to me throughout the trial that you faithfully discharged your duty to listen carefully to all the evidence and to observe each of the witnesses. I now ask you to give me that same close attention as I instruct you on the law. Let me start off with your function. You will determine whether the Commonwealth has proved its case beyond a reasonable doubt, and that is your function and your function alone. You are the sole and exclusive judges of the facts. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you. You alone decide what evidence to accept, how important the evidence is that you accept, and what conclusions all the believable evidence leads you to. You must decide whether the Commonwealth has met its burden of proof beyond a reasonable doubt based solely and entirely on the evidence as you have heard it and seen it in this courtroom, and on what you observed during the view and on nothing else. No bias, no prejudice, no fear, no favor. The fact that the case is brought in the name of the Commonwealth entitles the prosecution to no greater consideration or to any less consideration than any other litigant. All parties, whether prosecution or defendant, stand as equals at the bar of justice. You are not to be swayed by personal likes or dislikes. Emotion or sympathy, passion or prejudice has no place in your deliberations. The Commonwealth and Mr. Hernandez have a right to have the case judged by jurors who are just as fair and impartial as the lot of humanity will admit. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Mr. Hernandez has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. That is the awesome responsibility imposed upon you. Your focus is upon the evidence, the fair and impartial sifting of the evidence. I am the sole judge of the law. My job is to teach to you the law that you must follow in the case. You must take the law as I give it to you. You may not quarrel with it. You cannot say, well, I don't see why that is to be proven. Let's forget about that. You can't do that regardless of any opinion you may have as to what the law ought to be. You must follow what I am saying as to the law. That's the only fair way. That's why we have judges, so that the law is declared to be the same in every courtroom throughout the state. You can't take issue with it. Have in mind that you should listen to my entire instructions. All of my instructions are equally important, so please do not single out some and ignore others. And don't turn me out partway through and say, aha, the case turns on this or on that. That also would not be fair. Now, since you are the judges of the facts in this case, what tools have you to discharge your function? What are the sources of evidence in this case? Well, there is the testimony of the witnesses. The number of witnesses who may have been called is not important. You must decide what weight, if any, to give to their testimony. You have had a chance to listen to each of them, to observe each of them, to consider all of what they have said and how they have said it. The testimony of a law enforcement officer is not entitled to any greater or to any lesser weight simply because the witness works in law enforcement. As jurors, you have very broad powers with respect to the testimony of any witness. You are not required to accept testimony, even though the testimony may be uncontradicted and the witness is not impeached. You may believe everything that a witness has said on the witness stand. Likewise, you may disbelieve and disregard the testimony of any witness, as though that witness never testified. Between those two extremes, you may believe part of what a witness said and disbelieve other parts. You can decide, and you have the complete authority to decide, what you believe and what weight you think the testimony deserves. If you do not believe that a witness's testimony that something happened, your disbelief, of course, is not evidence that it did not in fact happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. Now, how do you go about making this critically important judgment about the credibility, that is, the believability of what the witnesses told you while they were testifying? Use your common sense. Every bit of knowledge and experience that you have as reasonable jurors about the human condition you may bring to bear in analyzing this case. Use your observations of each witness. How did the witness answer questions, both on direct and on cross-examination? Was the witness a candid, a frank, a forthright person? Was the witness evasive, a suspect in some way? Did the witness appear to know what the witness was talking about? What was the opportunity or lack of opportunity that the witness had to see and to learn the facts about which he or she was testifying? What was the ability of the witness to understand, to recall, to accurately describe those things about which a witness was testifying? Did the witness strike you as someone trying to report the witness's knowledge accurately? Was the witness friendly with or hostile to anyone involved in this case? Does the witness have any bias, prejudice, loyalty, or hostility that might cause the witness to slant his or her testimony? Did the witness stand to gain or lose anything depending upon how this case comes out? Did that, in your view, color the witness's testimony? Did the witness have an incentive or motive to testify in a certain fashion? In assessing the incentive or motive of Mr. Bradley, you may take into account evidence that he is currently facing criminal charges and consider whether he might have believed that he might stand to gain anything by testifying in a particular way, even in the absence of any agreement with the Commonwealth. It is for you to decide how much weight, if any, to give a pending charge in determining the witness's credibility. You may also consider evidence that Mr. Bradley was previously convicted of a crime in connection with your evaluation of his credibility or truthfulness. That is, you may consider whether or not it affects the witness's believability and the weight you decide to give his testimony, and for no other reason. It is for you to decide how much weight, if any, to give a prior conviction in determining the witness's credibility. Another factor you may take into consideration in assessing credibility is the grant of immunity given to certain witnesses called by the Commonwealth. A grant of immunity means that the witness has been ordered by a court to testify and cannot be prosecuted for or on account of any matter about which he or she has testified, except for perjury committed while the witness is testifying. The testimony of an immunized witness should be scrutinized with particular care. A defendant cannot be convicted solely on the testimony of a person granted immunity. It is required that there be some evidence in support of the testimony of an immunized witness on at least one element of proof essential to convict the defendant. A grant of immunity does not constitute endorsement of the witness's veracity or truthfulness. Neither the prosecution in calling the witnesses who were immunized nor the court issuing the immunity orders has any ability to determine who is truthful or not. The credibility of a witness who testified pursuant to grant of immunity, as with all witnesses, is solely for you to decide. Finally, with respect to each witness, consider the reasonableness or the unreasonableness of the testimony itself, the probability or improbability of that testimony. Does the testimony have the ring of truth? There is one more point about witnesses to address: expert witnesses. This term refers to witnesses who have had specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things that they have personally seen or heard or felt. However, in a variety of cases, issues arise that are beyond the experience of laypersons. And in those types of cases, we allow a person with specialized training or experience, called an expert witness, to testify, and to testify not only to facts, but also to opinions and the reasons for his or her opinions on issues that are within the witness's field of experience and are relevant and material to the case. Because a particular witness has specialized training and experience in his or her field does not put that witness on a higher level than any other witness. And you ought to treat a so-called expert witness just like you would treat any other witness. In other words, as with any witness, it is completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It is also entirely up to you to decide whether you accept the facts relied on by such a witness, and to decide what conclusions, if any, you draw from that witness's testimony. You are free to reject the testimony and opinion of such a witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony opinion of that witness in whole or in part. You must remember that expert witnesses do not decide cases. Juries do. In the last analysis, an expert witness is like any other witness in the sense that you alone make the judgment about how much credibility and weight you give to the expert's testimony and what conclusions you draw from that testimony. Let me say a few more things about the credibility of witnesses and your powers with respect to the testimony of witnesses. Any testimony that was admitted for a limited purpose may be used for that limited purpose only and for that purpose alone. Next, when you evaluate the testimony that a witness gave here in court, you may consider whether that witness made any earlier statement that differs from, is inconsistent with, or contradicts in any way his or her in-court testimony. The earlier statement was admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely. Or you may decide that it is not so affected, but that is the only purpose for which you may use the earlier statement. You may not consider the earlier statement as evidence or proof of the truth of any fact contained in the statement. The testimony of a witness may be rehabilitated or supported by showing that he previously made statements that are consistent with his present testimony. The prior statement was admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any fact contained in that statement. Next, testimony regarding statements that may have been made to the defendant, other than statements of intent, were admitted into evidence solely with respect to the defendant's knowledge or to give context to any responses the defendant may have made. You are not to consider any such statement made to the defendant as establishing the truth of any fact contained in the statement. In addition to the testimony of the witnesses, what other evidence is there in the case? Well, there are the numbered exhibits, all of which you will have in the jury room so that you may examine them to whatever extent you wish. Exhibits are evidence, and you have the same powers with respect to exhibits that you have with respect to the testimony of the witnesses. Look them over and decide the weight, that is the value that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give each exhibit. When you look at the photographs that have been introduced in evidence, please do not allow your verdict to be influenced in any way by the fact that some of these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based upon sympathy or pity that might be occasioned by a photograph. Consider such exhibits only as they may draw attention to a clinical medical status, the nature of the injuries, or the position of the body. Some exhibits purport to be compilations based according to the testimony on records that have been introduced into evidence in this case. It is up to you whether to credit or not credit that testimony, taking into account the underlying records as well as verbal testimony from other witnesses. You should keep in mind that a witness who has made a compilation after the fact does not claim to be the original maker of business records. To the extent that you may find such an exhibit relevant in evaluating any issue in this case, you should always keep in mind that it is simply a compilation that was admitted because it might be of some assistance to you. You are the sole judge of the accuracy of any compilation introduced as an exhibit. Lastly, we've had some stipulations. A stipulation is evidence, indeed evidence that's not disputed. So those are the sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? Well, as I've told you, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I charge you to use your common sense. Consider the evidence in the case for the purposes for which it has been admitted. Give it a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence is proof of a chain of circumstances from which you may infer or conclude that a fact exists, even though it has not been proven directly. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Whether the evidence is direct or circumstantial, the Commonwealth must prove the guilt of the defendant beyond a reasonable doubt from all of the evidence in the case. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one that is not too remote in the ordinary course of events. You may not guess, you may not speculate or engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. Speculation is forbidden. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. In order to convict the defendant, you must find that all of the evidence and the reasonable inference that you have drawn, taken together, prove that he is guilty beyond a reasonable doubt. Let me give you an example of an inference. This courtroom has no windows in it. So if you're sitting here and you see people coming in with wet, straggly hair or shaking off coats and umbrellas, you can infer that it's raining outside. And that's a fair and logical and reasonable inference from what you see. You can't look out the windows and see it raining, but you can infer that it did. However, if seeing those facts or observing what you've observed, you decide there's a hurricane going on, or that it's already rained 2 inches, or decide the exact time it started, then those would all be guesses. That's speculation. You cannot engage in conjecture, guesswork, speculation, or flights of fancy, but you are entitled to draw reasonable inferences warranted by the evidence in the fashion I've just described. Now, there is one inference that I want to discuss with you for a minute, and that is an inference of consciousness of guilt. If the Commonwealth has proven that the defendant did or said something that appears designed to cover up the commission of a crime, you may take that into account and consider whether such action indicates feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt tend to show actual guilt on any of these charges. You are not required to draw such inferences and must use great care and caution before you draw an inference of guilt from such evidence. You should not do so unless such an inference appears reasonable in light of all the circumstances of this case. Consider and weigh all the testimony and evidence. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. But you should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect or show feelings of guilt with respect to the charges before you. Please also bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. Where a defendant knowingly participates in the commission of a crime with one or more persons with the intent required for the offense, the law refers to this cooperative conduct as a joint venture. Evidence that Mr. Wallace and or Mr. Ortiz may have engaged in behavior that amounts to consciousness of guilt on the part of either of these individuals cannot be used by you as evidence from which you may draw an inference against the defendant, unless the Commonwealth has proven beyond a reasonable doubt that the defendant and such other individual were engaged in a joint venture and that the actions of the other were committed during the pendency of the joint venture and in furtherance of it. With respect to any activity that may have been undertaken by Ms. Jenkins, you cannot consider any such action as evidence of the defendant's consciousness of guilt, unless the Commonwealth has proved that the actions were undertaken at the direction of the defendant or with his consent or authorization. You may not consider evidence of an unequivocal denial by the defendant of involvement in the killing of Mr. Lloyd or a declaration by the defendant of his innocence as any evidence of consciousness of guilt. The defendant was not obligated to report a crime or to volunteer information about a crime to the police. Therefore, you may not draw an adverse inference from any failure by the defendant to volunteer any information he may have known about Odin Lloyd's death to the police. Before I go any further, let me point out what's not evidence in this case. The defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that he is guilty. It is not up to the defendant to prove that he is innocent. Under our system of law, a defendant has the perfect right to say to the Commonwealth, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word." The fact that the defendant did not testify has nothing to do with the question of whether he is guilty or not guilty. You are not to draw any adverse inference against the defendant because he did not testify. Under your oath as jurors, you are bound not to consider it in any way or even discuss it during your deliberations. You must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits introduced into evidence during the trial. Evidence is also not the opening statements of counsel or the closing arguments of counsel. The attorneys weren't there. They don't know themselves what went on. They marshal the evidence and may lay out for you what it may tend to show, but they are not sources of evidence themselves. Any questions that the attorneys asked during the course of trial, or any statements they made during the course of trial, those are not evidence. A lawyer's question, no matter how artfully phrased, is not evidence. A question can only be used to give meaning to a witness's answer. If a question included any suggestions or insinuations, you are to ignore them unless the witness was permitted to answer the question and confirmed those suggestions. Also, how you might react to these attorneys as persons. Do you like them or dislike them or their mannerisms or the way they present has nothing at all to do with your decision. Your reactions to the attorneys are not to be considered by you. Let me also remind you that it is the duty of attorneys to object when evidence is offered that they believe may be inadmissible under our rules of evidence. They also had an obligation to request to be heard at sidebar if they wish to address questions of law, which the law requires me to rule on out of your hearing. The purpose of such objections and rulings is not to keep relevant information from you, just the opposite. It is to make sure that what you hear is relevant and admissible, and that the evidence is presented in a way that gives you a fair opportunity to evaluate its worth. Any such activity on the part of any counsel in this case, in making objections, in opposing objections, in requesting sidebar conferences, or in making legal arguments, is not to be considered by you. If I sustained an objection to a question, that is, did not allow the witness to answer questions put to them, you are to disregard those questions and not speculate or guess about what the answers might have been. An unanswered question is not evidence. If I overruled an objection, you should give no more weight to the answer than you would have given it had no objection been made. Now, equally important, if you think that I think anything at all about how this case should come out from the way I have presided and conducted myself, any ruling I may have made during the course of this trial, or from anything I may have said or am saying now in these instructions, or from any question I may have asked, I most earnestly instruct you to disregard it. That's not my function. My role is to rule on the admissibility of evidence and to instruct you in the law. Your decision must be made free from interference from anyone, myself included. You are not to listen to my voice inflections with the purpose of trying to ascertain my thoughts as to a possible verdict. So if you somehow think that I have some view as to the proper outcome of this case, disregard it, put it aside, put it out of your mind, because it is your function and not mine to decide the merits of this case. Your collective memory of the evidence controls, not the memory of the lawyers and not my memory. Anything you may have seen or heard when the court was not in session is not evidence. Also, any testimony as to which an objection was sustained after it was given or I ordered stricken is not evidence and must not be considered by you. It has absolutely no bearing in this case. It is as though the testimony was never given. Even though it may be difficult for you to put something out of your minds, you must disregard it entirely. Evidence that was stricken must play no part whatsoever in your deliberations. Let me specifically remind you about the testimony of Kyle Aspinwall that the court ordered stricken from the record, namely his opinion, if any, as to what an object in the home surveillance video appeared to him to be, to the extent that his opinion as to what it appeared to be was based upon the rear of the slide, the front strap, the trigger guard, or anything other than the back strap, including the tang. Any such testimony is no longer in evidence, and you must disregard it, put it out of your mind. It is your sworn duty not to consider information that has been stricken from the record in deciding this case. Now, we've also had several chalks. A chalk is used to illustrate testimony. It is not evidence itself, and you need not accept any chalk as accurate. You will not have the chalks with you in the jury room. Any document or item that was marked for identification only, or shown or used by a witness to refresh his or her recollection that was not made a numbered exhibit, is not evidence, and you will not have it in the jury room. Now, we've gone over the sources of evidence, and we've talked about what our roles are and the attorney's roles. We've touched on what's not evidence in the case. Now let's get to this case. We'll start with a very basic principle, and this is it. Aaron Hernandez stands before you with a presumption of innocence. This presumption is with the defendant at the onset of the trial and continues with him through all of the stages of trial, unless and until he is proved guilty beyond a reasonable doubt. You are to draw absolutely no inference whatsoever from the fact that search warrants may have been issued, that the defendant was arrested, or that he was indicted. None of these are to be regarded by you as a circumstance tending to incriminate the defendant or creating against him any unfavorable impression. An indictment is not evidence. It is merely a piece of paper, a procedural mechanism for bringing a criminal charge and accusation before jurors like yourselves and for notifying the defendant of the charges against him. The fact that there may have been a prior proceeding, such as grand jury proceedings, does not change or alter in the least the presumption of innocence. You are not to draw any adverse inferences from the fact that there may have been any such proceeding, nor are you to speculate as to the result of any such proceeding. The presumption of innocence teaches us that the Commonwealth has to prove it all, each essential element of the offenses with which Mr. Hernandez has been charged. The presumption of innocence is not an idle theory to be discarded or disposed of by the jury by caprice, passion, or prejudice. The presumption of innocence alone compels you to find the defendant not guilty unless you are satisfied beyond a reasonable doubt of his guilt after careful and impartial consideration of all the evidence in the case. Mr. Hernandez didn't have to explain anything. The burden of proof who has to prove the case rests on the Commonwealth, not on Mr. Hernandez. That burden never shifts. A defendant never has any burden to prove his innocence or to produce evidence. Mr. Hernandez doesn't have anything to prove to you here. So if you, after careful and impartial consideration of all of the evidence in the case, have a reasonable doubt of the defendant's guilt as to any of the offenses charged, your verdict on that charge must be not guilty. The only way Mr. Hernandez can be found guilty of any of these charges is if you come unanimously to believe that the Commonwealth has proved each and every element of the specific charge beyond a reasonable doubt. Speculation, suspicion, or conjecture on your part that the defendant may have been guilty of a crime cannot be the basis for a guilty verdict. So that sets the stage for a description to you of what I mean when I say and use the phrase proof beyond a reasonable doubt. That phrase has received a great deal of attention over the years from the courts of the Commonwealth and elsewhere. And because the courts have taken such particular pains to focus on that phrase and to define and tell us what they mean by it, I'm going to read from a decision of the Supreme Judicial Court of the Commonwealth. In its decision, the court says this: "The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against him." What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. So now we're going to go to what it is that the Commonwealth has to prove beyond a reasonable doubt. And I'm going to suggest that you all stand for a moment and stretch. In this case, the Commonwealth has charged Mr. Hernandez with the crimes of murder, unlawful possession of a firearm, and unlawful possession of ammunition. To each of these charges, Mr. Hernandez has pleaded not guilty. Your decision as to one charge should not control your decision as to another. Each charge is entitled to your individual determination. Before I discuss the elements of each of the offenses with which the defendant is charged, let me instruct you that motive is not an element of any of the crimes charged. The Commonwealth is not required to prove motive. Turning first to the charge of murder, the Commonwealth is not required to prove that the defendant himself performed the act that caused Mr. Lloyd's death. However, to establish that the defendant is guilty of murder, the Commonwealth must prove two things beyond a reasonable doubt. First, the Commonwealth must prove that the defendant knowingly participated in the commission of the crime. Second, the Commonwealth must prove that he did so with the intent required to commit the crime. Such knowing participation by the defendant may take many forms. It may take the form of personally committing the acts that constitute the crime, or of aiding or assisting another in those acts. It may take the form of the defendant asking or encouraging another person to commit the crime, or of helping to plan the commission of the crime. Alternatively, it may take the form of the defendant agreeing to stand by at or near the scene of the crime, to act as a lookout, or to provide aid or assistance in committing the crime, or in escaping, if such help becomes necessary. An agreement to help, if needed, does not need to be made through a formal or explicit written, or oral advance plan or agreement. It is enough if the defendant and at least one other person consciously acted together before or during the crime with the intent of making the crime succeed. It is not enough that a defendant agreed to assist after the commission of the crime. Accordingly, you cannot find that the Commonwealth has proved that the defendant knowingly participated in the commission of the crime if his only participation was in assisting the perpetrator or perpetrators in escaping or concealing evidence, and if the agreement to assist arose after the killing. As I have said, any express or implied agreement by the defendant to act in concert with another during or after the killing must have arisen before or during the commission of the crime. The Commonwealth must also prove beyond a reasonable doubt that at the time the defendant knowingly participated in the commission of the crime of murder, he possessed or shared the intent required for that crime. You are permitted but not required to infer the defendant's mental state or intent from his knowledge of the circumstances or any subsequent participation in the crime. The inferences you draw must be reasonable, and you may rely on your experience and common sense in determining the defendant's knowledge and intent. Mere knowledge that a crime is to be committed is not sufficient to convict the defendant. The Commonwealth must also prove more than mere association with the perpetrator or perpetrators of the crime, either before or after its commission. It must also prove more than a failure to take appropriate steps to prevent the commission of the crime. Mere presence at the scene of the crime is not enough to convict the defendant. Presence alone does not establish the defendant's knowing participation in the crime, even if he knew about the intended crime in advance and took no steps to prevent it. To find the defendant guilty of murder, you must find that the Commonwealth has proved beyond a reasonable doubt that he intentionally participated in some fashion in committing the crime of murder, and that he had or shared the intent required to commit the crime. It is not enough to show that the defendant simply was present when the crime was committed or that he knew about it in advance. Murder is the unlawful killing of a human being. There are two different degrees of murder: murder in the first degree and murder in the second degree. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories: murder with deliberate premeditation and/or murder with extreme atrocity or cruelty. You are to consider each of these theories and may find the defendant not guilty or guilty on one or two of these theories. Your verdict must be unanimous, whether it be not guilty or guilty of one or more theories of murder. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate block or blocks on the verdict slip as to each theory on which you agree unanimously. I will begin by instructing you on the elements for each of these theories of murder in the first degree. I will next instruct you on murder in the second degree. I will then review the verdict slip with you. Whenever in the course of these instructions on the elements of the crime of murder, I state that the Commonwealth must prove that the defendant caused the death of Odin Lloyd, or that the defendant committed the killing, or that the defendant intended to do an act, I do not mean that the Commonwealth is required to prove that the defendant personally performed such act or intended to personally perform the act. As I have told you, the knowing participation which the Commonwealth must prove beyond a reasonable doubt may take the form of the defendant personally committing the acts that constitute the crime, or of aiding and assisting another in those acts. Please keep that in mind whenever I use these phrases. What the Commonwealth must prove is that the defendant knowingly participated in the commission of the crime of murder with the intent required to commit the crime. I will first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1. The defendant caused the death of Odin Lloyd. 2. The defendant intended to kill Odin Lloyd. That is, the defendant consciously and purposefully intended to cause Odin Lloyd's death. 3. The defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Odin Lloyd. A defendant's act is the cause of Odin Lloyd's death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Odin Lloyd. That is, the defendant consciously and purposefully intended to cause Odin Lloyd's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. In deciding whether the defendant intended to kill Odin Lloyd and whether he formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant was affected by his consumption of alcohol or drugs. A defendant may form the required intent and act with deliberate premeditation, even if he consumed alcohol or drugs. But you may consider such evidence in determining whether the Commonwealth has proved these elements of murder in the first degree with deliberate premeditation beyond a reasonable doubt. Next, I will define the elements of murder in the first degree with extreme atrocity or cruelty. You shall consider this theory of murder in the first degree, regardless whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove the defendant guilty of first-degree murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1. The defendant caused the death of Odin Lloyd. 2. The defendant either intended to kill Odin Lloyd or intended to cause grievous bodily harm to Odin Lloyd, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood that death would result. 3. The killing was committed with extreme atrocity or cruelty. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Odin Lloyd. A defendant's act, once again, is the cause of Odin Lloyd's death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Odin Lloyd, or intended to cause grievous bodily harm to Odin Lloyd, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, this second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Odin Lloyd. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the death of Odin Lloyd. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily injury, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by his consumption of alcohol or drugs. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of a human life. You must determine whether the method or mode of a killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of the deceased with extreme atrocity or cruelty, you must consider the following factors. 1. Whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2. The consciousness and degree of suffering of the deceased. 3. The extent of the injuries to the deceased. 4. The number of blows delivered. 5. The manner, degree, and severity of the force used. 6. The nature of the weapon, instrument, or method used. And 7. The disproportion between the means needed to cause death and those employed. This seventh factor refers to whether the means used were excessive and out of proportion to what would be needed to kill a person. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors I've just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of the effect on the defendant of his consumption of alcohol or drugs, in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killing with extreme atrocity or cruelty. In order to prove murder in the second degree, the Commonwealth must prove each of the following elements. 1. The defendant caused the death of Odin Lloyd. 2. The defendant intended to kill Odin Lloyd or intended to cause grievous bodily harm to Odin Lloyd, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. In deciding whether the defendant intended to kill, intended to cause grievous bodily injury, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by his consumption of alcohol or drugs. As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. A firearm is a dangerous weapon as a matter of law. You cannot draw such an inference against the defendant unless the Commonwealth has proved that the defendant either himself used a firearm against Mr. Lloyd or that he knew that a person with whom he was knowingly participating in the commission of the act that caused Mr. Lloyd's death was armed with a firearm, that this individual intended to use and did use it on Odin Lloyd, and that the defendant shared the intent that it be so used. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of murder in the first degree or of murder in the second degree, you must find him not guilty. Mark, do you have another verdict slip? The verdict slip for the indictment charging murder gives you three alternatives: not guilty, or guilty of murder in the first degree, or guilty of murder in the second degree. When you are unanimous as to any one of those three alternatives, the foreperson will check the appropriate box. If you convict the defendant of murder in the first degree, the foreperson must also check the appropriate block or blocks on the verdict slip as to each theory on which you agree unanimously that the defendant is guilty of murder in the first degree. Next, the defendant is charged with unlawful possession of a firearm. Section 10A of Chapter 269 of our general laws provides that whoever, except as provided by statute, knowingly has in his possession or knowingly has under his control in a vehicle a firearm, loaded or unloaded as defined by law, without either being present in or on his residence or place of business, or having in effect a license to carry firearms, shall be punished. This indictment pertains solely to the alleged possession of a .45 caliber firearm by Mr. Hernandez on June 17, 2013 in North Attleboro. The Commonwealth is not required to prove that the defendant himself possessed the alleged .45 caliber firearm. However, to establish that the defendant is guilty of unlawful possession of a firearm, the Commonwealth must prove two things beyond a reasonable doubt. First, the Commonwealth must prove that the defendant knowingly participated in the commission of the crime of unlawful possession of a firearm. Second, the Commonwealth must prove that he did so with the intent required to commit the crime. Knowing participation by the defendant may take many forms. It may take the form of the defendant personally committing the acts that constitute the crime, or of aiding or assisting another in those acts. Please apply all the instructions I have previously given to you as to the meaning of the phrase knowing participation. The Commonwealth must also prove beyond a reasonable doubt that at the time the defendant knowingly participated in the commission of the crime of unlawful possession of a firearm, he possessed or shared the intent required for that crime. In addition to all the instructions I've already given to you regarding proof of intent, because an element of this offense is that a person who committed the crime possessed a firearm, the Commonwealth must prove beyond a reasonable doubt either that the defendant himself possessed the firearm or that the defendant knew that a person with whom he participated in the commission of the crime possessed the firearm. However, mere knowledge that a participant in the crime had possession of a firearm is not sufficient to hold the defendant liable for the acts of that participant. The Commonwealth must also prove that the defendant knowingly participated in the commission of the crime with the intent required to commit the crime. When in the course of these instructions on the elements of the crime of unlawful possession of a firearm, I state that the Commonwealth must prove that the defendant possessed a firearm or had a firearm under his control in a vehicle, I do not mean that the Commonwealth is required to prove that the defendant himself possessed a firearm or had one under his control in a vehicle. As I have told you, the knowing participation, which the Commonwealth must prove beyond a reasonable doubt, may take the form of the defendant personally committing the acts that constitute the crime, or of aiding and assisting another in those acts. Keep that in mind whenever I use these phrases. What the Commonwealth must prove is that the defendant knowingly participated in the commission of the crime of unlawful possession of a firearm with the intent required to commit the crime. To prove the defendant guilty of unlawful possession of a firearm, the Commonwealth must prove beyond a reasonable doubt each of the following elements. 1. Mr. Hernandez possessed a firearm or had a firearm under his control in a vehicle while he was in North Attleboro on June 17, 2013. 2. Mr. Hernandez knew that he possessed a firearm or had a firearm under his control in a vehicle. 3. The defendant possessed the firearm outside of his residence or place of business. I will now discuss each of these requirements in more detail. First element that the Commonwealth must prove beyond a reasonable doubt is that Mr. Hernandez possessed a firearm or had a firearm under his control in a vehicle while he was in North Attleboro on June 17, 2013. The only firearm to which this indictment pertains is a .45 caliber firearm. In order for the Commonwealth to prove that an individual had an item knowingly under his control in a vehicle, the Commonwealth is required to prove beyond a reasonable doubt that the individual was in possession of the firearm in the vehicle. The law recognizes two kinds of possession: actual possession and constructive possession. Actual possession exists when an individual has physical control over an object and the intent to exercise that control. For example, I possess the pencil I'm holding in my hand right now. I know it's a pencil. I have control over it. I can do what I want with it. A person who, although not in actual possession, knowingly has both the power and the intention at any given time to exercise dominion, power, or control over an object is in constructive possession of the object. Thus, constructive possession requires that an individual know the location of an object, be able to exercise control over that object, and intend to exercise that control. For example, I'm in constructive possession of my car keys, which I know are in the top drawer of the desk in my lobby, and which I intend to use to drive home later today. By control, as I've used that word, I mean the power and ability to decide what is to be done with the object in question and the intention to exercise control over the object. The Commonwealth is not required to prove possession for any set length of time. Possession may be joint or exclusive. In other words, more than one person may possess an object simultaneously. Moreover, a person need not own an object in order to be in possession of it. Possession of an object may be proven by circumstantial evidence and the reasonable inferences drawn from that evidence. You need not draw such an inference, however. Indeed, whether such an inference is appropriate in this case is for you to decide based on all the circumstances. Presence and awareness alone is not the equivalent of possession. Therefore, mere presence in the same vehicle or in the same location as a firearm, or mere knowledge of its physical location, does not amount to constructive possession. There must be more. The Commonwealth must also prove beyond a reasonable doubt that the item possessed was a firearm. As defined by our law, a firearm is a pistol, revolver, or other weapon, loaded or unloaded, from which a shot or bullet can be discharged, and the length of whose barrel is less than 16 inches. Therefore, for an item to constitute a firearm, it must be a weapon, it must be capable of discharging a shot or bullet, and it must have a barrel length of less than 16 inches. By barrel length, I mean the portion of the weapon through which a shot or bullet is driven, guided, or stabilized, including the chamber. The second element the Commonwealth must prove beyond a reasonable doubt is that Mr. Hernandez knew that the item he possessed was a firearm. If the item was a conventional firearm with its obvious dangers, the Commonwealth is not required to prove that Mr. Hernandez knew that the item met the legal definition of a firearm. To prove this element, the Commonwealth must prove beyond a reasonable doubt either that the defendant himself possessed the firearm and knew that it was a firearm, or that the defendant knew that a person with whom he knowingly participated in the commission of the crime possessed a firearm. The Commonwealth is not required to prove that the defendant knew that the law requires a person to have a license to possess a firearm legally. The license element of this indictment is not relevant to your deliberations, and you should put it out of your minds. The third element the Commonwealth must prove beyond a reasonable doubt is that the defendant possessed the firearm outside of his residence or place of business. This indictment does not pertain to any alleged possession of a firearm by the defendant in his residence. If after considering all the evidence you are persuaded that the Commonwealth has proved beyond a reasonable doubt each of the elements of unlawful possession of a firearm that I've just described, namely one, that Mr. Hernandez possessed a firearm, namely a .45 caliber firearm, or had such a firearm under his control in a vehicle while in North Attleboro on June 17, 2013. 2, that Mr. Hernandez knew that he possessed a firearm. And 3, that Mr. Hernandez possessed the firearm outside his residence or place of business, then you should return a verdict of guilty on the indictment charging unlawful possession of a firearm. If you are not persuaded that the Commonwealth has proved each of these elements beyond a reasonable doubt, then your verdict on this indictment must be not guilty. The verdict slip for this indictment gives you 2 alternatives: not guilty or guilty of unlawful possession of a firearm. When you are unanimous as to any one of those alternatives, the foreperson will check the appropriate box. Finally, the defendant has been charged with unlawful possession of ammunition. Section 10H of Chapter 269 of our general laws provides that whoever possesses ammunition without complying with the requirements relating to firearm identification cards shall be punished. This indictment pertains to the alleged possession by Mr. Hernandez of .22 caliber ammunition in his residence on June 22, 2013. On this indictment, the Commonwealth is proceeding on a theory that Mr. Hernandez himself possessed the ammunition at issue. In order to prove that Mr. Hernandez committed this offense, the Commonwealth must prove beyond a reasonable doubt each of the following 2 elements. 1, the defendant possessed an item that met the legal definition of ammunition. 2, the defendant knew that he possessed ammunition. The first element the Commonwealth must prove beyond a reasonable doubt is that Mr. Hernandez possessed an item that met the legal definition of ammunition. The law, as I have told you, recognizes 2 kinds of possession: actual possession and constructive possession. The Commonwealth alleges that Mr. Hernandez had constructive possession of .22 caliber ammunition allegedly found in his residence. As I have told you, a person who, although not in actual possession, knowingly has both the power and the intention at any given time to exercise dominion, power, or control over an object is in constructive possession of the object. Constructive possession requires that an individual know the location of an object, be able to exercise control over that object, and intend to exercise that control. By control, as I've used that word, I mean the power and ability to decide what is to be done with the object in question and the intention to exercise control over the object. The Commonwealth is not required to prove possession for any set length of time. Possession may be joint or exclusive. A person need not own an object in order to be in possession of it. Possession of an object may be proven by circumstantial evidence and the reasonable inferences drawn from that evidence. You need not draw such an inference, however. Indeed, whether such an inference is appropriate in this case is for you to decide based on all of the circumstances. Presence and awareness alone is not the equivalent of possession. Therefore, mere presence in the same residence as ammunition or mere knowledge of its physical location does not amount to constructive possession. There must be more. The Commonwealth must also prove beyond a reasonable doubt that what Mr. Hernandez possessed was ammunition. As defined by our law, ammunition means cartridges or cartridge cases, primers, igniter, bullets, or propellant powder designed for use in any firearm, rifle, or shotgun. The second element that the Commonwealth must prove beyond a reasonable doubt is that the defendant knew that he possessed ammunition within the common meaning of that term. This requires you to make a decision about the defendant's state of mind at that time. Consider all of the facts and circumstances and evidence. The Commonwealth is not required to prove that the defendant knew that the law required him to have a firearm identification card to possess ammunition legally. The firearm identification card element of this indictment is not relevant to your deliberations, and you should put it out of your minds. In sum, if you are persuaded that the Commonwealth has proved beyond a reasonable doubt each of the elements of unlawful possession of ammunition that I have just defined, namely 1, that Mr. Hernandez possessed ammunition, namely .22 caliber ammunition, on June 22, 2013, and 2, that he knew he possessed ammunition, then you should return a verdict of guilty to the charge of unlawful possession of ammunition. If you are not persuaded that the Commonwealth has proved both of these elements beyond a reasonable doubt, then your verdict on this indictment must be not guilty. The verdict slip for this indictment gives you 2 alternatives: not guilty or guilty of unlawful possession of ammunition. When you are unanimous as to any one of those alternatives, the foreperson will check the appropriate box. There are a few more matters before I conclude the charge. The first matter is that one of my functions is to appoint a foreperson for the jury, and in this case I appoint juror in seat number 5 as foreperson. Now, being foreperson carries with it neither more honor nor more pay. You are all equal in your voices and your votes as jurors in this case, and you all should discuss the matter equally among yourselves. The reason we have a foreperson is really twofold. First, the foreperson facilitates, if you will, or helps organize the discussions among the jurors during your deliberations. The foreperson has the responsibility of making sure that the deliberations proceed in a fair and orderly manner, that every juror participates, and that you listen carefully and patiently to the views of each juror. Secondly, the foreperson will fill out the verdict slip speaking for the whole jury when you have reached unanimous verdicts, and will report in open court on behalf of the jury your verdicts when you are ready to return your verdicts. The next matter is the law permits only 12 people to deliberate in a criminal case. There are 15 of you here, so shortly we will, by lot, reduce your number to 12. We choose 18 of you originally so that the process may properly go on to a conclusion if someone should get sick or have a personal loss in the family or some emergency. If you're chosen as an alternate, you'll be kept apart in another room from the deliberating jury, and although it may be frustrating, you may not discuss the case with one another or with anyone else. Like the deliberating jurors, you are under a continuing obligation not to have any contact whatsoever with the defendant, the lawyers, or any witness. If we get into a situation where we lose a deliberating juror because of some personal emergency or sickness, then I'll send an alternate into the jury room. So important is the role of the alternate that if I have to replace a juror, I will tell the deliberating jury to start again right from scratch as reconstituted, no matter how long the deliberations have gone. So if you're chosen as an alternate, please don't think that your contribution here is not valued. It is. The verdict of the 12 of you who deliberate in this case must be unanimous. That is, all 12 of you must agree, whether the verdict be not guilty or guilty. 12 people must be of one mind. Now let me say a few words about your deliberations in the jury room. You have been permitted to take notes, and some of you have chosen to do so. You may, of course, refer to your notes to remind you of what's going on in the trial, but keep in mind that the memory of a juror who did not take notes may be just as good. Any notes that may have been taken necessarily will be incomplete and inadvertently may be inaccurate. They are not transcripts. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Just a word about transcripts. We don't have the capacity to give you transcripts of the evidence. So again, let me emphasize, it is your memory of what the evidence is that controls. Deliberate there in the jury room, set things up so that each and every one of you can fully and fairly express your opinion about the particular charge that you're talking about. Deliberate all together, not 2 or 3 of you huddled off in a corner. The use of cell phones and other personal wireless devices is not allowed during jury deliberations or during any breaks in your deliberations until you have been excused for the day. It is probably not a good idea to take a straw vote at the outset of your deliberations. If you do that, you might think that under your oath you're bound to adhere to that initial impression. That is not so. If you have a strong view about any aspect of this case, no one suggests you surrender it. A unanimous verdict means the unanimous verdict of each juror independently agreeing. But you are permitted to deliberate together to see whether the views of other jurors do affect your views of the matter. Bear in mind that you are not partisans. You are not advocates. No member of this juror should ever attempt to communicate with the court by any means other than a signed writing. Any question you may have about this case should be in writing signed by the foreperson. If you have a question, please state only the question and do not disclose any preliminary votes or views of the jurors. The foreperson will deliver the written communication to one of the court officers who will see to it that it is delivered to me. I will call in the lawyers, we will discuss the communication and get a response to you. Remember, because I am only the judge of the law and you are the judges of the facts, I cannot answer any question you may have as to what the evidence was. You cannot seek an answer to any question you may have by consulting a dictionary or any other book or source of information, including the internet. Until I accept your verdicts, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any chat room, or blog, or website, such as Facebook, LinkedIn, YouTube, or Twitter, to communicate to anyone any information about this case, or to conduct any research about this case, or to receive any information from anyone about this case. This instruction applies with full force to the alternates. Ladies and gentlemen, the pace of your deliberations is entirely up to you. Your deliberations are to be conducted in secret. You are not to disclose to anyone outside the jury room, not even to the court, how you stand numerically or otherwise on the matters before you. You are not to discuss, even with the court officers who are looking after you, how things are going in deliberations, what people said, how you're feeling. Your communications with the court officers should have to do with matters of scheduling, breaks when you come back to the courtroom, that kind of thing. But do not, even with the court officers, discuss what's going on in the jury room. You'll note shortly from the oath taken by the court officers that they too, as well as any other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching the merits of this case. The foreperson will have a separate verdict slip for each indictment. In addition to checking off the verdict on which you unanimously agree on each slip, the foreperson will also sign and date each verdict slip, inform the court officers, and they will bring you back into the courtroom to receive your verdicts. That's one time during the case when we ask you to stand. We ask you to stand out of respect, and the clerk says words to the effect, first to the foreperson and then to all of you, have you reached a unanimous verdict? You say yes if you have. Then the verdict slips are passed to me. I check that the foreperson has signed and dated the verdict slips, and I give them back to the clerk. The foreperson then will read your verdicts out loud, and the clerk will ask, so say you foreperson, so say you all. If, as you are standing there in the jury box, you are satisfied with the conscientiousness of your duty, faithfully performed, you will have done what's required of you as jurors in this case. Before we reduce the jury, I need to speak with counsel and ask them to come to sidebar. They have a chance now to tell me if I misstated something or left anything out. Mark, I'd like you to move the exhibits between before we reduce the jury, I also want to let you know that when, after we do reduce the jury and you go into the jury room, it's going to take a little while to go through all the exhibits. I want counsel to go through all the exhibits, put them all in order, when that is done, we will send those exhibits into you, and we'll also be sending the verdict slips, and I will also be sending to you a written copy of my charge, my instructions on the law, which you're free to review to whatever extent you wish. And with respect to the exhibits that are going in, it's policy that we don't send in a firearm along with the ammunition. So either some ammunition will be sent in, but not the exhibit that is a firearm or alleged to be a firearm, or vice versa. And if at any point you want to switch, you can, foreperson can send a note and we'll switch. Also, the telephones, the cell phones that have been marked as exhibits in this case are inoperable. They will be in heat-sealed bags, and I would ask you not to take them out of the bags, but there will be, as marked as an exhibit in this case, or exhibits, will be screenshots taken from the phones. You may reduce the jury.
The juror in seat number 2 is selected as our first alternate juror. The juror in seat number 4 is selected as our second alternate juror. The juror in seat number 12 is selected as our third alternate juror.
Me swear in the court officers.
Could I have each court officer please raise your right hand? Do you each severally and solemnly swear that you will take charge of this jury and conduct them to some safe and convenient place, that you will suffer no person to speak to them, nor speak to them yourselves, except by order of the court to ask them if they are agreed, and that you will not allow them to separate until they are discharged by their verdict, unless otherwise ordered to do so by this court. So help you God.
I do.
You may take the jurors.
Court all rise, the jury.
So I imagine it's going to take you a few minutes to go through the exhibits. If you could just, when you're done, the clerk will let me know when you're done, and then I'd like you, so I can come back out and we'll put on the record that you're satisfied with the exhibits, and again, put on the record with respect to the verdict slips. Thank you.
Could all rise? We're going to stand in recess.